Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to another episode of Building the Bridge. I have the pleasure of having with me today Chris Cavaliere, who is a partner at Shoemaker Law Firm in Tampa and specializes in employment law. Thanks for being with us today, Chris. Appreciate it.
Thank you so much for having me, Steve. Looking forward to it.
So let's talk about categorizing or classifying employees. How do you classify an employee versus independent contractor?
Yeah, that's such a great question, Steve. It's a really hot topic these days, right? And it's got some serious consequences, which I think we'll get to in a different video. But the short answer to this, Steve, is that there's really not a black and white answer as to whether a worker is an employee or an independent contractor. There's a lot of gray here, and what makes these things more difficult is that there are various tests that are used by different courts and different governmental agencies. They don't all use the same test, right? So a court might use one test when deciding if a worker is an employee for the purposes of an employment leave law, like the Family Medical Leave Act, the FMLA. Okay. And the IRS might use a completely different test when determining whether a company should have classified a worker as an employee for the purposes of withholding taxes, right, or paying the employer's share. So that makes it more difficult. But, I think some things are good to go over from a high level as to what is an independent contractor and an employee, and what are some of the important factors that pretty much all courts and agencies look into.
So, I work with a lot of foreign companies that launch U.S. operations, and their way of thinking is W-2 or 1099, and it's black or white, right? It's either they're full-time or part-time employees, or they're just independently contracted. It's that simple, right? It's not.
It isn't, and I'm so glad you brought up that point, because I think it hits on two really important things. Number one, just because the employer and the worker choose to define the relationship one way, right? Just because the worker says, I'm cool with you calling me an independent contractor, I'm cool with you calling me a 1099, okay, doesn't mean that legally speaking, a court or an agency is going to agree with that classification, right? So it's not strictly a matter of we're two adults here making this decision. There really are factors that the courts and agencies look into, which I'll get to in a second. And the second important thing that you bring up is that a lot of companies, and I see this go wrong a lot. A lot of companies will say, well, just because, all I have to do is cut this person a 1099 or a W-2, and that defines the relationship, right? Some companies might even, I've even heard some companies refer to their workers as a 1099 employee. And you and I know this, and we laugh, but I mean, if I'm running a business and I'm not a lawyer, I wouldn't know this either. But here's a pro tip. There's no such thing as a 1099 employee, right? You get a 1099 if you're an independent contractor, right. You get a W-2 if you're an employee. And we can go over some of the factors if you'd like to go there next on what are some of these factors that courts.
Yeah. So when does this come up? Because you mentioned the courts, you mentioned different agencies that interpret the facts to the law. When does this actually come up? I guess when there's conflict, when does this actually become a matter that needs to be addressed or to be fought over?
Sure. So this can become an issue in a variety of ways. And I think you and I are doing a completely separate video where we'll do a deeper dive on this. But from a super high level, it can go wrong in terms of worker files or workers' compensation claim, right? It goes to the Florida agency that presides over workers' comp claims, and they say, I'm sorry, sir or ma'am, but your claim is being denied because you're an independent contractor. That comes as news to the independent contractor, and the independent contractor or the worker says, well, actually, I was really an employee. So it can come up there. It can come up in the realm of IRS tax issues. Maybe the IRS does an audit or has some other reason to look into, look underneath the hood and say, have you really classified your workers correctly? Because we have a feeling that you're doing things a little bit shady here, and maybe you should have been withholding taxes and paying your employer share, making your contributions towards Social Security and Medicare, and you haven't done that because you have misclassified your workers as independent contractors. There are a variety of ways where this can go wrong. So it makes it all the more important for employers to get out in front of this and do the due diligence on the front end so that they don't get surprised with this when they get hit with liability on the back end.
Yeah, you anticipated my follow-up question, which is, what do you tell your employer clients how to get in front of this? How to most concretely define this going before they even get started to make sure they can minimize potential problems?
Yeah, absolutely. So the first step is these things are super fact specific, right? So I will have a very fact intensive and detailed conversation with the client as to, what does this person do for your company, right? So this might be a good time to go over some of the factors that courts and agencies look at.
Sure.
And step two is obviously if we feel that the person's been properly classified as an independent contractor, you certainly want to have them sign a full independent contractor agreement. Not that that's going to win the day, but it can help you in various ways. And it's always a good idea to have a full independent contractor agreement. But on that step one, when we have these conversations with our clients about, is this worker an employee or an independent contractor? Again, courts and agencies use a variety of different tests. So I tend to take a conservative approach on this. And one thing is for sure, that regardless of the agency, regardless of the court, almost all of them look at the amount of control that the company has over the worker.
Okay.
And generally speaking, the more control and oversight that the company has over the worker, more likely it is that this person's going to be seen to be an employee, right? A really simple analogy, because of course this video is very short, so we're just the tip of the iceberg here.
Yes.
But a really, really good smell test for companies, and I can only speak for federal law and Florida law, of course. Some states might have additional wrinkles on this. Is try to use the house painter test. This is what I kind of, right? When you hire someone to paint your house, that person's allowed to paint other folks' houses, right? A house painter is a true independent contractor.
No
They're allowed
exclusivity. Got it.
Yeah, exactly. There's no exclusivity in the relationship. You're allowed to paint other houses. I might tell you what color I want you to use or what I want the result to look like, but I'm not going to tell you what brush strokes to use. I'm not going to tell you the minute details of how to do the job. I'm not going to withhold taxes, right, from your pay. I'm not going to give you benefits. I'm not going to give you paid time off. Really importantly, I'm not going to give you a set schedule. You can come and go as you please, right? These factors all kind of go toward that one big idea, which is control. And courts look at other factors too, but that tends to be one of the more important factors. More control, more likely it is that the person's an employee. Less control and oversight, more likely they've been properly classified as a 1099 independent contractor.
Wow, that's some great tips, Chris. I always tell people that if the law were simple, then I wouldn't have a job. And that's certainly true in your case as well. How do people get in touch with you if they have questions, if they want to get out in front of this?
Sure. You can call me. My direct line is 813-676-7208, or you can send me an email at cavaliere@shoemaker.com.
Fantastic. Thanks so much for your time today, Chris.
Thanks, Steve. Great being here.